Leases and property management. Chapter 10. Essential matters to learn in this chapter. A lease is a contract to transfer possession of real estate in exchange for rent. Property owner, the landlord, are also called the lessor, and the user is called the tenant, also called the leaser. The landlord is called the leaser, and the user is called the lessor. Landlord interest is called the lease fee, but the lease fee estate. The tenant is interest called the leasehold. Leasehold estate. Leases 1 year longer must be written to enforceable under state through frauds. Type of leasehold estates or estates for years has stated expiration date, which can be at any period. Estates for year to year, automatically renewed only once, unless one party gives the notice of the termination to the other. Tenancy at will. Either party may terminate the agreement. Tenancy of sufferance. The tenant has remained in the property after lease expiration. Common lease provisions include who pays operating expense. Grossly, the landlord pays operating expense. Net lease, the tenant pays operating expense. Operating expense generally include property tax, maintenance, insurance. Net, and triple net are terms used for the emphasis of the obligation of the tenant. Operating expense does not include, but a debit service, the interest, principal payments, and their income stays, taxes, cover the financing expense obligation of the owner. Percentage leases are often used for retail property. If the tenant pays a basic rent plus percentage of the gross business sales above a certain amount, escalation provisions that cause pass-throughs, although the increase of the expense due to the paid is by the leaser. The lesser graduated lease of the rent increase present intervals. Index or indexed leases all allow increase based on change the economic index, such as cost of living index. A lease may or may not include leaser's right to assign, give it to another. The lessor's right to assign, give it another all the rights of the lease. Sublet gives part of the lease rights to another, creating a new lease. The original lessor remains liable to fulfill the lease unless released by the lessor remains liable to fulfill the lease unless released by the leaser. Sale of the property does not change the lease. The new owners must observe the tenant rights as described in the lease. The lease is typically terminated by performance which occurs if both parties observe the full-term lease on expiration. The tenant may remove or keep the trade fixture of the restaurant that often includes kitchen equipment, signage, and bar stools. Breach lease occurs when only one party violates lease provisions. When tenant vacates without paying the rent, the tenant may be liable for the damages. Typically, if they continue paying the rent at the end of the lease enforced by the court, landlord must make an effort to mitigate determined damages by seeking substitute tenant. A tenant may withhold rent until the leaser violation. The tenant may withhold rent upon certain leaser violations. Death of either party normally does not terminate a lease. The estate of the descendant is responsible for honoring remaining terms of the lease. Some cities have adopted rent controls to prevent sharply increasing rent from being passed on, especially resident terms. Real estate license does not require property manager, broker. License requirement does not apply to on-site manager. Where were we? A lease is a contract transfer of property with the exchange of the rent. Real estate owners known as the landlord or the leaser is usually uses the tenant or lessor. Landlord remains in revisionary right to retain the right to use the property upon expiration of the lease. Tenant holds the leasehold estate of the personal property interest that gives the tenant the right to use the property for the lease term under the conditions stipulated with the lease. With respect to the lease, statute frauds usually require the only lease for more than 1 year having to be in writing. This means some states possible for short-term lease 1 year or less to be oral, but always the best practice for any contract to be written. Disputing oral contracts in court can get very messy. You should check your state's law. Leases, though, do not require short-term lease to be written. Type of leasehold estates for years, estates for year to year, tenancy at will, and tenancy sufferance. State for years is stated expiration date. That period included maybe 1 day or more than 50 years with lease terms end. The tenant is to vacate the property. Estate from year to year, also called periodic estate from period to period, does not fix the expiration date. Automatically renewed after another period week, month, year, unless adequate notice of termination is given in one period. Its notice is generally adequate less than 1 year's acceptance in the case of year-to-year lease. Tenants at will allows the tenant to remain with the consent of the landlord at any time. Either the tenant and landlord may terminate the agreement. Embellments arise by operational law to give the tenants at will right to harvest grow crops. The tenant who holds property beyond lease term without landlord's consent is a holdover tenant. The form of the state is called a tenancy at sufferance. A holdover tenancy has a few rights at any leasehold estate. Some of the common lease provisions: rent may be payable in any form of the parties agree upon. Typically, rent is payable in money, but it's also payable in crops, labor, and so on. Whatever the landlord tenant agree upon. Straight or flat lease call for level amounts for rent. Step up, step down, gratitude, or reprisals lease provide the fluctuation amount of the rent. Percentage lease. A percentage lease requires the tenant to pay of his rent a percentage of the sale, usually basic rent, and stipulated with a guaranteed minimum amount. For example, the lease may require the retailer or tenant to pay $10,000 rent annually plus 2% gross sales excess of $500,000. Should be a sale to be under $500. The rent is $10,000 for the sale of $600,000. The rent is $1,200,000. This is a $10,000 basic plus 2% of the $100,000 excess sale. Gross net and lease. A lease is requires the landlord to pay operating expenses such as the utility, the repairs, insurance, property taxes. Called the gross lease. Leaser considers the rent to be gross income and receive the net operating income after he pays operating expenses out of his own pocket. The net lease requires the tenant to pay operating expense. Landlord receives the rent as a new rent net return. The terms net and gross are then often used may adequate and inadequate to describe the lease. Hybrid, semi-net, net, triple net are used to describe the degree in which parties may be held responsible for the operating expense, interest expense, income tax are the leaser's obligation. They are not operating expenses. Carefully reading the lease interested parties is necessary to avoid misunderstanding. Escalation graduated leases. Escalation step provisions are found in long-term gross leases. Should certain operating expenses exceed the designated amount with the increase passed on to the tenant, the graduated lease can increase. Certain individuals, such as every year or 2 or 5 year intervals. Index lease. Indexed or indexed lease is one who its rent is changed periodically in accordance with public economic index, such as cost of living index published by the Bureau of Labor Statistics. Assignment and subletting. Unless specially prohibited in lease, tenant has the right to assign or sublet any other case of the original lease. Lessors remains liable to fulfill the lease contract. Assignment occurs when the tenant transfer the right of obligation stipulated in the lease to a third party or assigner. Should the original tenant wish to keep the portion of the property his own use or to permit property for the third party to form a shorter than his lease, he may subletting. Involves second lease. The original tenant becomes a leaser for the part of the property for entire property for part of the lease term. Sale of the property. When leased property is sold, the lease reserves the sale of the tenant is allowed to continue with the use under the lease terms. Termination of lease. Normal termination of a lease is a result of the performance both landlord and tenants have fulfilled the lease obligation. This error is said to be performance. Another method of terminating a lease is an agreement. The landlord-tenant may agree to terminate the lease before its stated expiration date. Compensation may include such an agreement. Breach may also cause termination, which either party fails to pay under the lease. There is said to be a breach. Although the breach can terminate a lease, it does not cancel all provisions. Violating party may be held liable for the damage. Tenant has a breach of the lease. The landlord's remedy is court. Using a court order, the landlord may eject or evict the tenant. A tenant who vacates the property before fixed expiration date of the lease is responsible for the remaining rent. The landlord must attempt to mitigate reduced damages. In other words, he must attempt to lease the property to another tenant to offset the lost rent from the tenant who has vacated the property. Eventually leave. The tenant owns only the difference in rent plus expenses. incurred obtaining a substitute tenant. However, the vacating property fails to terminate the lease except for the constructive eviction. This form of breach, the landlord makes it very difficult, impossible for the tenant to enjoy the leased premises as contracted. In effect, the landlord action forces the tenant to leave. Example: the very noisy repair work that goes on night after night in an apartment building, turning off the utilities for long periods of time, closing the parking lot in a retail shopping center. In most cases, places, situation with death or leaser or lesser does not terminate the lease. The lessor remains liable to the end of the current lease, and the lease is binding on the leaser's estate and higher heirs. Ground lease is a long-term lease. Land or airspace tenant usually builds whatever improvements are desired. The landlord receives what is called a triple rent, net rent. This means the tenant pays not only operating expenses, also property tax, mortgage payments. Ground leases are very long periods of time, usually 25 or as many as 99 years. Sale and leaseback. Sale and leaseback, a party who owns their use of the property sells it to an investor, leases it back, becoming the tenant. Often the sales generate a significant amount of cash for the seller occupant, which are profitable used in his business. Lease provisions frequently encountered in this described below. Not all the provisions will be found in every lease. Alright, provision and purpose. Premises describe the property being leased. Terms state the term of the lease. Rent describe the rental amount due to the place payable. Constructing buildings improvement to describe the improvement of the personal proposed property to be renovated in suit of the tenant. Common areas describe maintenance, common use areas such as those shopping centers. Taxes states will provide ad valorem taxes, escalation amounts, repairs. State which party is responsible for the repairs or maintenance. Alteration state responsibility right of the tenant to alter improvements. Liability insurance designates party who is responsible to carry liability insurance extent. Other insurance designates party who is responsible to carry hazard insurance to the extent damaged by fire. Casualty describes the operational lease in the event of fire or other casualty. Payment of the utility state which the party may charge water, heat, gas, electrical, sewage, disposal of other utility. Subordination describes the right between the landowner and the tenant into event of the mortgage foreclosure. Certificate of lease obligates the tenant to inform mortgage lender of occupancy and rent status. Condemnation and eminent domain describe the operating lease in the event of the partial taking of the property. Compliance of the law requires landlord tenant to comply with the laws and ordinances. Access by the landlord allows landlord to inspect the property. Mechanical liens describe the discharge of the mechanical liens. Assignment, subletting, limits of tenant's right to assign or sublet. Non-built liability of the landlord. Free landlord liability due to injury or damage without premises right to cure the defaults. All landlords to cure the tenant defaults require reimbursement. Use permits tenant for the use of the property. Specific person notice describe the method of serving the notice to a party. Definition of terms used in the lease. Partial invalidity describe the operation of the lease when parts of the lease are held to be invalid. Waiver of redemption permits tenant waive all the rates upon lease expiration. Bankruptcy and insolvency describe required notice operating in lease in the event of bankruptcy. Default lease default. Surrender describes how a tenant will leave the property under expiration of the lease. Arbitration provides a method to settle disputes. Broker's notes the brokers involved in the lease negotiation. Cumberton describe the rights and obligation of the parties to deliver the returned property with respect to liens, easements, etc. Alright, quiet enjoyment agrees the landlord tenant forms may hold and enjoy the property without interference. Other restrictions may limit the leasing space of the shopping centers to a competitor. Entire agreement. Save the written lease in the entire arrangement or agreement. Property percentage clause stipulates the condition affecting percentage lease. Recapture clause stipulates for the percentage lease of the lessor may terminate lease if the lesser revenues do not attain a specified level with a certain length of time. Alright, landlord-tenant law. Most states, some localities have collected many provisions of these laws and special enactments. A body of law called the landlord-tenant law. Most often, the bodies of the law apply to the residential leasing of parent homes, etc. Specifically define certain areas of the relation between landlord and tenant. Lease laws itself, very old, has been created largely to benefit the owner of leased property. The landlord-tenant law therefore tends to concentrate upon tenants' rights, although it often includes specifically tenant responsibilities. Over the dozen states have adopted some of the modification model law called the Uniform Residential Landlord Tenant Act, also known as URLTA. The title, the law applies only to residential leasing, some exemption, hotels, motels, mobile home park lots. The Uniform Residential Landlord Tenant Act concerns some of the subjects as security deposit rights and landlords and tenant conditions of the property. Since states have not adopted the Uniform Residential, some states have not adopted the Uniform Residential Landlord Tenant Act as statute. Usually have laws covering same things. However, their laws are general, more favorable to the landlords than the Uniform Residential Landlord Tenant Act. With or without the Uniform Residential Landlord Tenant Act, many states and localities have enacted more stringent laws governing their tenants' rights. You should check whether your state has laws considering either following. Note if there are only local laws, either subject or probably would covered by license examination. Rent control. Rent control allows the government to limit the amount of rent charge exists in New York City. A few other major metropolitan areas where market rent are usually high. Withholding rent. Some of the state's localities, all tenants withhold rent if the property does not meet certain conditions. They usually involve the habitability safely, like in the conditions that do not meet the building health code. Some places laws are used allows tenants simply to refuse to pay until the landlord remedies the problem. In other words, the withheld rent must be used to remedy the illegal condition. If possible, must be paid in some sort of escrow account pending resolution of the problem. Laws prohibit the landlord for evicting tenants for non-payment of rent when the rent is withheld for a reason allowed by the law. In some states, require implied warranty habitability. Tenants may be withheld rent and promises of non-habitability until the landlord remedies the situation. Actual conditions allow the tenant to withhold rent vary considerably state to state, although some of the permit withholding in the case of a clear violation of building safety, sanitation, and health codes. Trade fixture. Trade fixture is attached to a rental facility tenancy who use the fixture of conducting business no matter how. The trade fixture is attached to the real estate of the personal property. Some of the examples of booth counters and bar stools, restaurant tanks, pumps, and the service station shelves in the retail store of the tenant may remove these expiration at the end of the expiration of the lease. If determined whether an item in the trade fixture courts will consider the manner of an attachment personal property generally be removed without damage. Adaptation of the article to the real estate items of the built and specifically to the install of a particular building are unlikely to be used in another or probably real estate. The intent of the parties when the property was attached. Property management. Property management is the business of seeking and negotiating with tenants over the other people of real estate with real estate brokerage function. Property management in all states are required to hold real estate states. Brokerage life of the resident manager for the apartments, building, of the projects are allowed by more states to function without license, provided that they do not manage any other properties than we are employed either by a property owner or property licensed property manager. Some brokers who claim property managers may do little more than fill tenant vacant properties, collect payment for doing so. Actual personal property of the manager does a lot more. In fact, he is able to do everything associated with the proper management of the property, so the owner needs not to do nothing at all. The property manager functions include leasing, negotiation, potential tenants, advertising, developing leasing plans, arrangement, maintenance, and repair, paying it bills out of rent receipts of the course property manager and paid for their service. Normally, the payment is percentage of the rent payments collected. However, they may be instead also receive a flat fee. A property manager may also have written contracts with the owner, at least oral agreement to explain the duties and responsibility. The agreement should include the manager's name, responsibility for your arrangement, which is often the percentage of gross income received. The manager duties typically include maintaining property and enhancing or at least preserving the value matters under the contract of training, meet the owner's goals when maximizing cash flow, minimizing tenant turnover. Certain special cases, lease agreements often found with the managed property, retail property, shopping centers, etc. often feature percentage leases. This type of lease, all of the part of the tenant rents is a percentage of its gross business revenue. The theory here is the well-managed popular shopping center will generate good business for the tenants as though will be willing to pay a part of the income as rent. Also, the property manager is encouraged to promote advertising the shopping center because by doing so, he gets more people to come to it, spend more money, thus generating more rent. Many percentage leases contain a recapture clause that allows the property manager to avoid the lease if the tenant does not lease a certain volume of business within a certain time in a way that the management avoids getting stuck with a poor tenant and one who does not do much business. That was chapter 10.